Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me as always is Senior Associate from MBK Chapman, Sam Keel. Sam, good morning.
Good morning, Mike. How are you?
I'm good, thank you very much. So Sam, today, and this is happening more and more now, I think you'll agree, this topic came to us based on a question we got. I can't remember what avenue it came through, whether it was YouTube or one of the vocal, Spotify or iHeart or whatever it was, but came to us from one of our podcast listeners who had asked about the business judgment rule.
Yeah.
And it was a good enough question that I thought, you know what, this is worthy. And I'm shocked that we hadn't done a whole show. We've mentioned the business judgment rule in at least 5 episodes in the past, and probably some shorts, right?
Absolutely.
But we've never done a full-length episode on it. And I thought we had for some reason. I would have bet we had.
Well, it comes out all the time. So we've covered it in passing, but yeah.
So
not a full episode.
We're going to do it today, okay? And we're going to go through we're going to talk about what it is, what it's for, why it exists, and, you know, what to do or how bad HOAs abuse the very real rule that exists. How do they abuse it to shut homeowners down? Or in other words, how do they rely on it incorrectly? Okay.
One of the most commonly misused applications of the doctrine. Overused.
Right. Overused. Okay, so the business judgment rule in itself is one of the most frequently cited doctrines in California HOA law. Okay, you're going to see it in dozens and dozens and dozens of appellate court cases that interpret the Davis-Sterling Act. It is one of the more central doctrines or rules that exists within the context of Davis-Sterling Act, even though the Corporation's Code section is not part of the Davis-Sterling Act that establishes it, but it is applied full force in the Davis-Sterling Act. And for a very good reason, by the way, we'll talk about, all right? But it creates problems when boards invoke it reflexively or incorrectly. And when I say boards, I'm including management as well, okay?
Absolutely.
I think 2 days ago, we released a full-length podcast on bad managers.
We did.
And we talked about or mentioned the business judgment rule in that podcast episode, but we may not have, not sure. I also recall doing a short recently as well. And I've got a few fact sheets on that topic up on the website, mbkchapman.com. Just go to the libraries tab, scroll down to fact sheets and type in BJR or business judgment rule, and you'll come up with a variety of different fact sheets and articles that I've written on the topic. But we see managers and HOA boards, bad ones, using it reflexively as a hammer in ways that it's not designed to be used. So the way they often frame it is just wrong, and we're gonna pierce that bubble. And we're gonna talk to you about what it really is, what it's for, how it's properly applied, and what it means in your day-to-day lives. Okay? The business judgment rule, to be just top level, does not decide disputes.
No.
Okay? At all. No. Okay? It doesn't bar lawsuits. It does not excuse misconduct on the part of the board. It is simply, as Sam's going to explain in a minute, a legal presumption that exists. Okay? And it's a statutorily created presumption. Okay? And with that, let's go to what it is. Because once you understand the pieces that make up the business judgment rule and the different factors on how it's applied, when it's over-applied, why it's over-applied, why it exists, you have a more broad understanding of how your HOA functions, okay, rightly or wrongly. So, Sam, to kick us off here, describe it in words that an intelligent 10th grader would understand. Very simple.
Okay.
And the reason I use that is a very famous professor of mine at Berkeley in my undergrad. I was in a political policy class, and we had to write a 100-page term paper, not including the 75 pages of footnotes or endnotes that I had. And his mantra, I took 2 of his classes. I had to write 2 100-page papers in the same term, but I made them the flip side of each. I had 2 classes from him. One was public policy, one was on PACs, political action committees. I used the same issue, but from different perspectives. I was able to double up or able to do the same research for both papers. So I got A's on it. But anyway, very famous. He used to be a speechwriter for various presidents. Very, very famous professor. Is probably dead now because he was old at the time. But he had a mantra that I have taken as my own and have repeated to every lawyer I've ever trained. And I've trained dozens and dozens and dozens and dozens of lawyers in legal writing. Okay? And that is, if a reasonably intelligent 10th grader does not understand what you wrote, then either you're not a good writer or you don't understand the topic well enough. He used to always say it, and I have adopted that, and I've been using that for over 30 years. Okay? So I want you to tell me, what is the BJR in a way that a reasonably intelligent 10th grader would understand?
Well, under that pressure now, Mike, so basically at its core, it's a legal presumption created statutorily, as you alluded to, that provides for barring misconduct or something to the contrary, a board of directors for an HOA has acted reasonably, and this is set forth under the Corporations Code section 7231.
Right. So in other words, I'm going to simplify even more than you did.
Yeah.
It is a legal presumption that assumes, barring evidence to the contrary, that a board has acted reasonably.
Correct.
Period.
Yeah.
Now, when we're dealing with a legal presumption, we see these in different areas of law when legal presumptions are created. What that typically does, and this is legal parlance and kind of how courts work, is it shifts the burden of proof.
Yeah.
In order to defeat a presumption, you've got to come up with evidence that shifts the burden back. Okay? You have to, if a presumption is given that X equals Y, you've got to show that X doesn't equal Y. Okay? Otherwise, they get the benefit of the presumption. So it's a powerful tool. So it creates a powerful presumption that a board has acted reasonably. How do you get over that presumption? Well, we'll talk about that later. You prove that something the board did wasn't reasonable or violated the law or something else, you defeat the presumption. Okay?
Yeah.
So, and you're right, the doctrine itself is rooted not in the Davis-Sterling Act, but in the Corporations Code, 7231. Now, that same code section does a little bit more than create this business judgment rule. It does a little bit more because it sets the standard of conduct for directors. In effect, if you remember our episodes on breach of fiduciary duty,
That's a good one, yeah.
it establishes that directors have a duty of good faith and loyalty to the HOA and to the members. And that duty of good faith and loyalty requires HOAs to act in a prudent manner, or even more simply, to act in a manner, objectively speaking, that a reasonable and ordinary person would act under the circumstances.
Exactly.
So, in other words, what would a reasonable person, knowing what you know, under the same facts and circumstances, decide to do?
Right.
That's the reasonable person standard. Okay? And the second thing 7231 does, in addition to kind of setting forth that standard of conduct, is it establishes the presumption we just talked about.
Yes.
It creates the presumption that came to be known as the business judgment rule, which we will refer to sometimes as the BJR. You'll see it both ways, both in written articles, certainly in normal usage. It's often called either the business judgment rule or the BJR.
Yeah.
Okay? Now, nowhere in the statute, Sam, correct me if I'm wrong, but nowhere in the statute does it require, in order for a director to be protected under the business judgment rule, it doesn't require them to get the right answer every time.
Oh, no.
It doesn't require them to choose the most intelligent or the most efficient or the best solution to something.
Not at all. Just that they've acted reasonably under those circumstances.
That's right.
Yeah.
The law doesn't require people to always make the right decision. You are protected if you make mistakes, as long as the mistakes you made were reasonable mistakes. Okay, Sam, so now that we've kind of covered the basics as to, what is the business judgment rule, let's dive a little bit deeper. And let's talk about what the BJR is designed to do. Okay? We've kind of touched base, we've done our signposting. Now what's it designed for? Okay? So the business judgment rule exists to protect volunteer directors from personal liability.
Yep.
Okay? When they make decisions in good faith and with reasonable care. That's important because, as we'll see in the last segment of today's show, it is not just a guaranteed presumption of reasonableness. No.
No, it's not. No.
It's you get the presumption, you get to benefit from the business judgment rule if you're a director, if you make decisions in good faith. For example, you don't breach fiduciary duty or violate the law.
Correct.
And you act reasonably. As long as you do those things, now you get the protection of the BJR. That's what it's designed for, okay? Now, that does not, nobody should read into that the obligation to be perfect.
No.
Nobody should read into that obligation to never make a mistake or to ever choose a solution that is not the best solution.
Right.
Maybe it's the third place solution.
It's reasonableness based on the circumstances available at the time.
And reasonableness never obligates you for perfection or to be the best.
No.
Otherwise, there'd be no such thing as, like, what is reasonable? It's standard, right? It's the mean. So as long as you act honestly, in good faith, and with reasonable care,
right,
you will be protected under the business judgment rule if you're a director, okay? So when a director meets those conditions, then the courts will not second guess certain things. One of the things that the court won't second guess is they're not going to second guess a board's decision to choose A or B. Which option did they choose?
There's a certain degree of deference in terms of those folks on site living within the community, knowing some of the nuanced needs of the community,
right,
catering to the desires of the membership. At least that's a public policy and the desire. And so they are reticent to interject unless you can prove up something to the contrary.
Right, but we'll cover that later. Right now we're talking about the courts aren't going to, if you've acted honestly, reasonably,
that's right,
and in good faith, the court's not going to second guess the specific option you chose, even if you neglected a better option or the option you chose in hindsight was wrong, okay? They're also not going to second guess how you balanced different considerations. This contractor's more expensive. This contractor has some complaints. This contractor's easier to get along with, but a little more expensive. This one is hard to get along with, but less expensive. The court's not going to second guess the factors, the weight of the factors you gave in making practical considerations, okay? And they're not going to ever look in hindsight, judge you by hindsight.
Right.
You're going to be judged by what you just said. You're going to be judged by what information was available to you at the time you made the decision, not later on what really happened. Your decision might end up being catastrophically wrong, but not because you didn't act reasonably or in good faith, but because circumstances, you didn't have enough information at the time and didn't realize you didn't.
Correct.
Stuff like that, right?
Yeah.
Okay, so bottom line, I guess, is that the business judgment rule is supposed to protect the decision-making process, okay? Not the result.
Correct.
Okay? And it doesn't reward good outcomes. Okay? What it rewards is good intentions and good faith, right? Reasonable judgment. Okay. Now, it's easy to say what the BJR does. It's more fun to talk about what it does not do, because that's going to come into play later when we talk about what bad HOAs do, okay? The biggest myth out there, as we'll see later in this show, is that a lot of bad managers or bad HOAs want members to believe that the business judgment rule is a barrier to legal review.
Oh, yeah.
And it's never a barrier to legal review, right? So, does the business judgment rule ever prevent a homeowner from filing a lawsuit?
Absolutely not.
No. Does it excuse violations of the Davis-Sterling Act?
No.
Okay.
No.
Does it prevent the board from examining the conduct of the board?
No, of course not.
No.
Yeah.
Does it ever excuse violation of the governing documents?
No.
And it certainly doesn't ever allow or validate acting outside the course and scope of your authority. You brought up, we were talking, and I'm not sure if you mentioned it in the show or it was before when we were talking about it, but you brought up a good example of a board member going up on a roof or something and doing some repairs by themselves, right?
An unlicensed individual essentially.
Just going up and saying, you know what, we're going to save money. I'm going to go up and just replace these things myself.
Can't do it.
When a license is required to do the work that director did, that is outside course and scope. So if they end up causing a penetration that causes a massive leak and causes real damages, this director is not going to benefit from the business judgment rule, right?
And there's no such thing as immunity stemming or stemming from the business judgment rule, and that's one of the other often misused applications of the doctrine.
Immunity is not a synonym
for
the business judgment rule. Immunity is you can't be that would prevent the lawsuit or prevent the claim against you. We just got done saying that's not what the BGR does.
Correct.
Immunity is literally has nothing to do with the business judgment rule at all.
Correct.
Okay.
Yep.
You're right. You're absolutely right. So the business judgment rule, we talked about why it's there. And in real life, it breaks down sometimes. It breaks down, and it's important to understand how. So the presumption that's created by Corporation Code 7231 is not absolute, right?
No.
We've literally, the entire mantra of this episode was that it's conditional.
Exactly.
Okay, and it applies only when directors meet the requirements necessary to benefit from this presumption. Okay, so let's talk about the common failure points.
Okay.
What's a big one that comes to mind for you?
Well, a big one is if they fail to act pursuant to authority that they have under the governing documents.
Okay,
so if it's an
they
extra,
violate the governing documents.
Exactly.
Talk to me about that. Give me one example.
Let's say the governing documents, specifically the bylaws, provide for a limit of a 1-year contractual engagement, and they basically completely ignore that, run afoul of it by engaging in a 5-year term contract with someone without a membership vote. That's something that's extrajudicial, so to speak, because I shouldn't have used that term, but it's outside of the bounds of the parameters set by the governing documents.
Right.
It would have required a membership vote. They completely bypassed that, so they didn't have authority.
How about this? How about the governing documents state that people have a right to, that there's no limitation on rentals, short-term rentals at all. Governing documents say nothing, okay? And then they go and they try to prevent somebody from renting. And they force that homeowner to file something in order to uphold their rights because they keep fining them, right?
Can't do it, yep.
That, you wouldn't get the benefit of the business judgment rule.
No.
Because you violated the governing documents, okay? So I call that bad faith, right?
Absolutely.
Okay. I'll do the next one. Conflict of interest, self-dealing.
That's a
We
common
had a
one.
whole episode on conflict of interest, right? If I'm a director and I'm conflicted and my HOA happens to be a mutual benefit nonprofit corporation, I'm subject to both California Davis-Sterling statute, the Davis-Sterling Act, and the statute related in the Corporations Code, which is which is binding on HOAs, but is not part of the Davis-Sterling Act. And the reason they go side by side is because if you happen to have an HOA that isn't a corporation, you might not be subject to the Corporations Code, but you are subject to the Davis-Sterling Act. If you're a corporation, HOA in California is subject to both, which would mean that if I was conflicted, not only do I have a duty to inform the board of the conflict, not only do I also have a duty to recuse myself from the discussion, okay, surrounding whatever's up for vote, but I must also abstain from voting.
And
I have to step out of the room.
For the abstention, and then the corporations go to a higher threshold of recusal.
Exactly.
Yep.
So I've got to abstain and recuse and get myself out entirely, and I have to disclose. If I fail to do that, and I involve myself in a decision that I have a personal stake in, like a normal director, I'm not going to be able to benefit from the business judgment rule.
No.
And by the way, tell me if I'm wrong here.
Go.
If the remaining board members know what my conflict is and don't instruct me to step out or do anything, they might not be able to take protection of that because they were aware of my conflict and did nothing to prevent me from voting or being a part of the conversation or disclosing.
That's right.
They have to put it on the record and say, hey, Bob, you need to step out, actually. Yeah. You can't vote on this. Or, Bob, this relates to your home. You can't be in the room with us, so you're going to have to step out, and we'll let you know how we vote
Here's
later.
a layer that I've actually encountered in a case where the attorney actually provides an opinion and recommendations for that interested or vested director to step out, recuse, and the other directors ignore that and essentially waive that.
Well, I think that's closer to gross negligence, which happens to be the next one, so cover that. Gross negligence, not protected. Business judgment rule.
Absolutely not.
Mere negligence probably get protected under the business judgment rule. Mere negligence. But gross negligence, no protection. If your lawyer says, whoa, guys, you guys can't do that. You need to do something else. And you go, thanks for sharing. And you go on, that's gross negligence.
Here's another example since we're touching on gross negligence. When you have consultants, let's say structural engineers, that put you on notice of a health, life, and safety issue, for instance, let's say a parking structure next to your association that is part of your property on the verge of collapse. Okay. And guess what? You not only have one, in some cases, you have multiple opinions, right? Reconfirming that same risk of exposure to liability. And the board essentially chooses not to do anything about it.
So, folks, just so you guys know, we had we recorded the entire episode earlier this morning, only to find out that partway through there was a glitch in our equipment, and there was some of the video got garbled and some of the audio got garbled intermittently. So we had to go and start over. So if you've noticed any kind of change in, the way something appears and it appears sudden to you, that's probably why. So I'm only bringing this up to let you in on, I can't remember if this example was kept or not kept from what is on the part of the video we were able to salvage, okay? I gave an example earlier today of a video I saw on Reddit recently where, and it wasn't in California because it was a structure made entirely of brick, and we don't have that, okay? But the person was it was obviously a multi-level unit, and this person, this 19 or 20-year-old male, was on a landing in the middle of a staircase. You have some stairs go up, and then there's a small landing, and then there's stairs going up here and a small landing, and that's the next floor. So you have two of these things for every floor. And he started going back and forth, and you could see the wall and the whole staircase buckling. That, to me, was shockingly unstable. When that wall goes, and it's going to go, people are going to die if they happen to be on that stair. It's going to tear down the whole thing. So use that example.
Yeah.
Because earlier this morning, and I don't know if it made it into the part we were able to salvage, but earlier this morning.
So that example, I mean, a standard building. This is not, the buildings that are prepared to withstand, let's say, seismic activity, like the high-rise buildings that we see in downtown LA, for instance. Right. But on a standard residential building, when you see that on its face, that ought to put you on notice that something
might be very wrong.
Something might be very wrong. So at minimum, that triggers your duty to investigate. So if you're a member of the board and that comes to your attention, hey, I need to make an inquiry, get someone who's duly qualified to look into this, and then they can kind of guide our next step decision making.
Right. Yeah. So and we're going to get to that. That's failure to act.
That's right.
Okay. We're on gross negligence now. So in the gross negligence category, let's say you went and you got that video from a homeowner and you went, that is something we need to take care of immediately. And you immediately send off an email. You tell your fellow directors and manager, hey, we need to get a hold of a structural engineer. It's an emergency. So we don't have to have a meeting about it. Let's just get this done. So you get a structural engineer to come over. He looks at it and goes, yeah, this thing's going to collapse imminently. It needs to be tagged now. Let's flag it off. This is has to be addressed now. And you say, well, we don't have the money right now. We're going to table this for the next meeting. Boy, oh boy, if something happens, I promise you're not going to benefit of the business judgment rule there. You ignored the advice of your expert.
That's right.
That is not only gross negligence, it's a failure to act. So we'll get to that in a second, okay? Well, let's deal with that next. So the next one is failure to act.
Okay.
It's not enough. It's not just that you lose a business judgment rule if you affirmatively do something bad, like you violate the statute, you violate the governing documents, you commit gross negligence. Yeah, those things will all get you out of the business judgment rule. But failing to act will also, and that is triggered when you have a duty to do something and you sit back and do nothing. So in the example that we're talking about with this, you get this video of the building shaking. Yeah. And you might not be a structural engineer, and there might be a perfectly acceptable explanation for that. But it should trigger you to, you know what, maybe we should get an engineer to look at this, or a contractor, somebody to come out and tell us, is this normal? And you brought up this LA building, right? You brought that up because earlier this morning in the original tape we did, we talked about the fact that these high rises in Tokyo and LA are put on rollers. And sometimes in high winds, if you have like say 50, 60 story building, and I've read that sometimes the buildings will sway several feet in each direction. Yeah. If you're looking at that and you see that as a normal person that doesn't understand the physics and the engineering aspect, that might be very concerning. And you, in a panic, might call somebody and they go, no, that's normal. It's designed that way. All right, no problem. But if you're one of those people that has a duty to act and you see that and you don't do anything and it turns out it was a problem, you're not, because it's objectively not reasonable to ignore something like that.
That's right.
It isn't.
Yeah.
If you saw this video I'm talking about, it was obvious that brick wall was coming down. And when the brick wall goes, the stair goes. The stairs go.
Especially when you're dealing with older buildings, residential, communities.
Exactly.
Yeah.
Right. Yeah. So we got bad faith, conflicts of interest, gross negligence, and failure to act. And the last one's acting outside legal authority.
Yeah.
And that's the example you brought up, where you have some board member that decides, I'm going to save ourselves some money, and they go up and start doing things that a license is required, or electrical work. They go in to try to fiddle around with the elevators, whatever. You can't do that.
Yeah.
You can't do that, okay? You're acting outside course and scope of your authority.
Right.
Lay board members are not, they're not expected to go and make, repairs, expert repairs on common areas. It's not in their wheelhouse.
Yeah, we see it all the time. We really do.
Right. So, now,
yeah.
We talk a lot about reliance on experts and consultants, et cetera. And that includes lawyers, accountants, architects, engineers, that sort of thing. Okay. But that reliance has boundaries. I just want to make it clear to you folks that you will always have the benefit of the business judgment rule as a director if you reasonably rely on the advice of your expert consultant. Okay? The accountant tells you everything's copacetic with the funding. You can take that accountant's word for it. The only exception to that is if your reliance in that expert itself is not reasonable. I'll give you an example. You are told that one of the directors newly elected to the board is a licensed professional structural engineer, and you do nothing to verify that person's bona fides. It turns out, no, he's just got experience and he's been around and he reads these things, but he has no licensing, no experience in the field. If you just take somebody's word for it and you don't do any of your own due diligence, that's not a reasonable reliance.
It's not.
Okay? If you rely on a paralegal to give you legal advice and try to equate that to an attorney, that's not reasonable. They need to be lawyers. Okay? So you are always going to be protected if you rely on the advice of a consultant or expert, as long as the reliance itself is reasonable. Yeah. Now, once your reliance on that person is reasonable, it doesn't matter how negligent they were. If they say X, Y, and Z, you can bank on it, even if they have committed gross negligence. Okay? Because you'll end up getting sued, let's say, but you'll just bring them in as for indemnity. Okay? The example that comes to mind for me is, let's say your HOA is one of those ones where the governing documents still say that no rentals at all are permitted anywhere on the property. We did a show recently on that issue. It is illegal now in the state of California for an HOA to completely ban rentals. Okay? So let's say you have a rental issue come up, and let's say you want to pass a new rule that says, okay, we're not going to allow any rentals at all. So you go to your lawyer and you pose the question, can we do that? And the lawyer comes back and goes, sure, go ahead. Okay? If that lawyer has any experience in property law or HOA law, then your reliance on that lawyer was reasonable, even though that answer was grossly negligent and completely wrong. So you go ahead and you follow that advice. Homeowner sues the HOA for violating the law, and you turn around and you're going to sue the lawyer for indemnity. You're going to win that. Okay? You're going to get the benefit of the business. Let's say this homeowner tries to name individual directors. You're going to get yourself out of that. You reasonably relied on an expert. Now, if you know that this lawyer has done criminal law for the last 40 years, and this is his first day doing property law, you're his first client that's in a civil case dealing with real estate or HOAs, and then he just suddenly, yeah, no problem, go ahead. I would argue that you didn't reasonably rely, that he didn't have sufficient experience and you should have known that.
Right.
Okay? Bottom line, reliance on consultants is very broad, but there's no such thing as a rubber stamp. You've got to, the reliance itself has to be reasonable. The advice doesn't have to be reasonable because they are not tasking you with second guessing your expert. Anything you want to add?
No, nothing else to add on that.
Great. Yeah. All right. So now let's go on to the real life example stuff. And this is basically, how do bad HOAs misuse in real life, misuse the business judgment rule? Okay. So let me start out by saying that most business judgment rule abuse happens outside of the confines or the context of a court case, out of litigation. What we see more often is that bad HOAs use the business judgment rule as a hammer against homeowners. They will cite the business judgment rule as basically a pressure phrase to end conversations or deter homeowners from pressing for explanations. And so the best way to learn, I think, is to give real life examples and apply things that you've learned to real life and see what it plays out. So let's do that.
Okay.
in real world examples, here's kind of what we're talking about. I'll start and then I'll clue you in on the next part, okay? The courts aren't going to second guess. So, no, let me do, I think it might even be easier, okay? Here's what a bad HOA might say, and this could be an indication to you that they're misusing the business judgment rule.
Mm-hmm.
Courts aren't going to second guess the decisions we made. Okay?
Yeah.
All right. What I'm talking about there is a homeowner's told that directly or indirectly, the court's going to not review the board's decision because of the business judgment rule.
Mm-hmm.
Okay? And you see that repeated constantly in public discussions and in Q&A style threads. I was on Reddit recently, and this was an issue that was posed by somebody. Their manager basically said, look, we're not giving you that information, and the court's not going to second guess. These are one of those decisions that the court's going to just rubber stamp.
Mm-hmm.
This was based on an inquiry that the homeowner had a right to make.
Right.
That's not proper application of the business judgment rule.
And there's several issues with that type of response. I mean, legal conclusions,
get
the manager getting into it. Yeah, yeah.
Okay.
Mm-hmm.
So cover this one for me. The business judgment rule protects us so we don't have to explain this to you.
No.
How do we see that play out?
Well, the most frequent of seeing that play out is when managers and directors use that in terms of like a gatekeeping type of a dynamic. They essentially use that as a pretext for not having to address legitimate questions in connection with, let's say, architectural applications.
Okay, good example.
Right?
So homeowner, let's not do architectural applications. We have a statutory basis for that under
We do.
4765. So let's do this. Homeowner asks for reasoning or is inquiring about what's your basis for spending that money on that thing?
Yep.
Let's do that.
Right.
Homeowner just asks that question during open flooring, let's say, right? Or sends an email into the manager and copies the directors, okay? Basic question, and it's a question that deserves a response, right?
Sure.
And the response by the manager / directors in your scenarios, well, look, that's a decision that is given to us as the board to make, and it doesn't really require an explanation. What is wrong with that response?
What's wrong with that response is that, first off, it's something that relates to the legitimate interest of a member or a membership in inquiring the either breakdown or basis for a decision making relating to the financial commitment by the association and the board. And so it's a legitimate question. The proper way of addressing that is to really give them some form of an answer. They don't have to justify every detail and nuance of their decision making per se. And if it's a first exchange, meaning there's not been some preceding, back and forth, but they've already adequately addressed that
this person's
inquiry,
crazy and keeps asking the same questions.
To go ahead and use and apply the business judgment rule, or the BJR, as a conversation stopper on that issue.
Exactly. Yeah.
It's an absolute misuse, because that presumption of reasonableness, I mean, that in itself on its face is not a reasonable way of conducting themselves as a board.
Exactly right. Yeah. Okay. Here's another one that I hear, and I'm sure you do too. A bad board might use the business judgment rule as a shield in certain do-nothing situations. So, for example, homeowners complain that the HOA won't address a known problem, and the defenders respond that the board's protection under the business judgment rule allows them to sit back and do nothing. Now, in some cases, that might be true. For example, if doing nothing is within the course and scope of their duty and is not unreasonable, it's not a serious issue, right? Just because you're a stickler. Let's say we have homeowners that are sticklers that are a little crazy sometimes, right? They're sticklers, and they want, they're looking for ultra precision. Remember, business judgment rule doesn't require ultra precision.
No.
So let's say they complain, you guys should have done X, Y, and Z. And it's like, no, that's going way beyond the normal standard of care. We're not obligated to do that. I don't have a problem with them saying, no, we're not doing that. We're talking about things that a safety violation, and they do nothing, okay? Or you have, even if it's not safety, you have part of the common area that's not working anymore. So the pool isn't working. Okay, the heater's not working, and we want to use the pool during the winter. Okay, and then just doing nothing. That's what we're talking about, where there's a duty. Okay, when the HOA frames the issue, the business judgment rule, as being that sort of tool, they are misframing what the business judgment rule is.
They are,
and that's why we hammered home at the beginning of this podcast. All the business judgment rule is a presumption.
It is.
And it's available to you if you acted reasonably and in good faith. If you violate one or both of those, there's no business judgment rule. Okay? So misuse here occurs when bad HOAs treat the business judgment rule as a trump card, as a get-out-of-jail-free card.
That's right.
That's not it doesn't excuse bad conduct. It doesn't excuse unreasonable
It's
conduct.
not unconditional. It's not immunity. None of that.
It's based on, it's a doctrine that exists. You get this presumption only if you acted in a lawful, informed, and reasonable manner.
Correct.
Otherwise, kiss her goodbye. Now, you've now learned enough about the business judgment rule to probably be able to recognize it if you see it. So what do you do if your association is misusing the business judgment rule? And that could be, by the way, a misuse could be in the form of one of those ridiculous threat letters that the HOA board asks one of these, HOA attorneys to write for them. We did a whole show on the abuse of those letters. So go into our archives and look for that. It's a very interesting episode. But we gave examples on air we even popped up copies of these letters that were absolutely absurd on the part of the lawyer. To me, it was malpractice, okay, and unethical. But let's say that's what you're facing. What do you do when the business judgment rule is thrown at you as a trump card? Okay, well, one thing to avoid is don't get tricked into getting caught up in arguing the fairness issue. Okay, don't debate fairness or wisdom. All you have to do is steer the discussion back to the process and the authority.
And reasonableness.
And that's part of the process is the reasonableness.
That's right.
You steer it back to the statutory basis under 7231 of the Corporations Code. So here's how you do that. We don't just tell you the answer, we tell you how to get to the answer. Okay? There are 4 questions that you should ask that'll help you steer it back. Because as soon as you get caught up in arguing their narrative, they've already won. So don't. Okay? So you want the clean way to do this is to force a discussion back to process and authority. So here are the questions. Question 1, what inquiry, and I would put this in writing, okay? What inquiry did the board perform before making whatever decisions at issue here? Okay? What information did the board rely on? Okay? Was it relying on an expert?
Right.
Or did it rely on, because the president of the board, has been sitting for many years and is now the authority?
Yeah.
That's not reasonable reliance. That itself is not a qualification. Okay? Did the board consider any alternatives? And if so, what alternatives? And what governing document, provision, or statute, and it could be both, did the board rely on that would authorize that decision? That's it. That's the 4 questions.
Very good ones, yeah.
Those questions steer you back to where it should be. Because if they can't answer that, because if there is a gap that makes it impossible for them to answer those questions, they aren't going to get the business judgment rule. That's how you know.
Yeah.
I don't think I missed any. Do you think I missed any?
No, those are fantastic. Yeah. I mean, I phrase those in different variations all the time. When I do consultations or meet with clients.
Right.
Yeah.
But those are the 4. So play this back and write them down. Okay? So why does all this matter? This is kind of we're on the last segment here. Why does all this matter? Because understanding the business judgment rule is a tactically smart thing to do. And the reason is because it helps you separate 2 things that you need to understand the differences of. Okay? Do you remember these, or do you want me to hint you?
In terms of...
Because I brought it up before the show. I was telling you the direction I wanted to go.
The relevance of understanding the business judgment rule?
No. Okay, so I'll help you. I'll do the first one. So understanding the business judgment rule is tactically smart because it helps you understand or separate the dichotomy of the following 2 items. For example, a board decision that gets deference from a board decision that doesn't get deference.
Anticipatorily, obviously,
Right.
if you know the end game of how this is likely to be treated, the presumption, the nuggets, and the mechanics of, notice, reasonableness, what was the basis in terms of the authority, what was considered alternatives, and then, basically what were the nuts and bolts of the decision-making process. If you understand that, then you can frame and phrase inquiries, follow-ups accordingly. Right? To document it, to bolster your position, and to take arguments on and objections on their end off the table.
Right. To put that a little more simply and succinctly, when you understand the purpose behind the business judgment rule and how it's abused, in other words, how it's misused, if you understand those differences, you'll be able to recognize very easily which types of decisions will actually get the deference required by the business judgment rule and which ones won't.
Correct.
you'll understand just by hearing it, no, you're wrong about that. Actually, that's not how it works.
Right.
Or, no, they're right. They're going to get, the business judgment rule is going to protect them. You aren't going to waste your time spinning your wheels, challenging something if you've already recognized that the decision they made is protected by the business judgment rule.
Yeah.
But if they're misusing it or they're claiming protection and you know, let's say they ignored the advice of one of their experts, but they're claiming that this decision will be protected, you know that's not the case now. You'll know that no deference is going to be given there, and you'll know whether or not you want to pursue something.
Right.
And the second one is you'll be able to tell the difference between a genuine legal position that's got teeth and a bluff by the board.
Yeah.
Because I will tell you this, and this should not be news to anyone. Bad boards routinely overstate the strength of what the law allows them to do or not allows them to do. They will claim, they'll claim that governing documents prevent you from doing that. And you ask them where it is and they can't tell you because it doesn't exist. They're just wrong. They're either lying or they're wrong. Either way, they overstate, okay? By understanding the business judgment rule, you'll start to recognize when it's, no, they're right. It's a genuine legal position and they're going to be protected versus this is a bluff from them. They're too lazy to do their job, or they don't want me to get what I want. And so they're just going to tell me what they want me to hear, hoping that I won't go and check.
Yeah.
Either way, clarity to what the business judgment rule is and what its limitations are will allow you to see examples of when it's being implemented properly and when it won't. And that's really important in my opinion.
Huge. Yeah.
Business judgment rule, folks, is not a magical phrase that ends scrutiny, okay? It is a conditional presumption. And it's tied to good faith and reasonableness. If either of those or both are missing, there is no presumption. That means there's no business judgment rule. That presumption's gone, okay? And it's all under the lawful authority of the Corporations Code 7231. So when an HOA leans on the business judgment rule to avoid explaining what it did or why it did it, when they are otherwise obligated to, for example, denying an architectural application under 4765, they refuse to give an explanation when it's required by statute, right? When they do that, what they're telling you, they're signaling to you is that they can't defend its process. And if they can't defend the process, they don't get the benefit of the business judgment rule. And when that happens, who should people call?
Us, MBK Chapman.
That's right.
We'll go to bat for you.
And what will we do? We'll set their HOA straight. We'll go to bat for you.
Yeah.
If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel HOA Hell. If you'd like to leave a comment or ask a question, please do so. We love reading those. Until next time, have a wonderful day.